Story. Uh, I hope the screen is visible to you. There is an
It
interesting
is.
judgment, Suleman versus State of Himachal Pradesh, 2025. Okay? This judgment was delivered on 19/8/2025, 19th of August 2025. Okay? So this is an interesting judgment in the way that I would like to first ask you a question. अगर आप बोलते हो पाकिस्तान जिंदाबाद, ठीक है, will it attract punishment, jail time, sedition or not? If you are saying Pakistan Zindabad or Khalistan Zindabad, what do you think?
I don't think it should.
But it is an enemy state.
But we have freedom of speech.
Yes. So let's take a look at this thing. कि why it is ठीक है, saying Pakistan Zindabad or Khalistan Zindabad, why is it not punishable? ठीक है, पुलिस कैन अरेस्ट यू बट कोर्ट की रीजनिंग क्या है? We will take a look. All right. So Suleman versus state of Himachal Pradesh. Suleman, he was a resident of Himachal Pradesh, and he applied for bail in the Himachal Pradesh High Court. All right. So Himachal Pradesh High Court, a street vendor, he is the petitioner here. He has filed for bail application. A street vendor petitioner was accused of sedition under section 152 of the भारतीय न्याय संहिता 2023. So IPC का नाम चेंज हो चुका है. All right. It has been renamed as BNS, भारतीय न्याय संहिता 2023. All right. पहले जब in the IPC the section was 124A, ठीक है, सेडिशन का जो सेक्शन था. नाउ इट इज 152. ऑलराइट, बोथ द सेक्शंस आर क्वाइट सिमिलर, कुछ डिफरेंसेस हैं इनमें छोटे मोटे, बट द मेन थिंग सेडिशन दैट इज इन 152 सेक्शन नंबर. ऑलराइट, सो व्हाट वाज द केस? he shared a he shared a content on Facebook with the words Pakistan Zindabad, and thus he filed the present petition seeking regular bail. A single judge bench of Rakesh Kanthala, while observing that the complainant had no averment as to bring hatred or discontent towards the government established by law in India, and that merely posting Pakistan Zindabad without denouncing India was not seditious, and therefore directed the petitioner's release on bail. ठीक है? So what the single judge bench has said, that by saying Pakistan Zindabad, he has not denounced India. उसने इंडिया को नहीं छोड़ दिया है. All right? He is only saying a particular nation's Zindabad. All right? Suppose उसने बोल दिया होता है यूनाइटेड स्टेट जिंदाबाद, कनाडा जिंदाबाद. All right? जैसे half or most of our population, a large chunk of our population is in Canada, US, एंड आपने देखा होगा कनाडा का झंडा लगा के रखते हैं पीछे अपनी कार्स के पीछे, यूएस का फ्लैग लगा के रखते हैं. So that is also not sedition. Okay. So what is the background of the case? The petitioner was a poor, illiterate street vendor who ran a small fruit cart outside the informant's shop. जिसने इन्फॉर्म किया उसके दुकान के बाहर he had a small fruit cart. It was stated that he allegedly shared an AI generated image of the Prime Minister with the words Pakistan Zindabad, which was considered inflammatory and against the nation's interest. It was contended that petitioner, being illiterate, was unable to operate social media platforms. Contention क्या थी कि he is illiterate, ये कैसे social media चला सकता है? And his Facebook account was created by his son, and that the informant had access to his mobile phone and had shared the controversial reel. कि इनके बेटे जो थे उन्होंने ये रील शेयर की है, इन्होंने नहीं की. Alright? The petitioner's counsel submitted that the allegations in the FIR did not satisfy the ingredients of section 152 BNS, as there was no averment in the application that he has incited hatred among the members of the two groups, Hindu and Muslims. कि उन दोनों के बीच में कोई hatred उसने नहीं फैलाई है, right? Or that his act was likely to provoke disharmony or feelings of enmity, and only writing Pakistan Zindabad by itself did not amount to inciting hatred. ठीक है, these were the averments made by the petitioner's counsel. petitioner के जो advocate थे उनका ये सब बोलना था. Alright? The petitioner was in custody since 8th June 2025, and it was prayed that he be released on bail. The petition was opposed by filing a status report as asserting that a complaint was made to the police that the petitioner wrote in favor of Pakistan and against the Prime Minister of India. So police, they registered an FIR and a charge sheet was filed before the court on 6th August 2025. The Additional Advocate General submitted that the relationship between India and Pakistan was strained at the time when the post was shared, Pahalgam attack hua tha, and writing Pakistan Zindabad was anti-national. Therefore, he prayed that the present petition be dismissed. So government की तरफ से जो council थे उनकी क्या उनकी तरफ से क्या arguments थी that his petition of bail that should be dismissed and he was speaking against the nation, against national interests. All right? And council की क्या इसमें what were the propositions he made? He was illiterate and only saying Pakistan Zindabad does not disown by saying Pakistan Zindabad, he was not disowning his own country. All right. So what did the High Court do? They took a look at the previous cases. पहले जो cases हो चुके हैं in the Supreme Court, the High Court took a look at that also. So the same position was reiterated in Ram Ratan versus State of MP 2024 and Shabeen Ahmed versus State of UP. The court relied on Vinod Dua versus Union of India 2023, where it was observed that Section 124A of the Penal Code, IPC, equivalent to Section 152 BNS, दोनों जो है सेम है 124A of the IPC जो पहले था and अभी जो नया एक्ट है 152 BNS, they both are same, apply to such activities which were intended or which tend to create disorder or disturbance in public peace. Further, the court referred to Javed Ahmed Hazam versus State of Maharashtra, wherein it was reiterated that written or spoken words must have the tendency or intention of causing public disorder or disobedience of law and order. ऐसी टेंडेंसी होनी चाहिए उन वर्ड्स में कि मैंने पाकिस्तान जिंदाबाद अगर मैंने बोला है, इट शुड बी एबल टू क्रिएट पब्लिक डिसऑर्डर, disobedience of law and order. But simply the words that he said कि पाकिस्तान जिंदाबाद, उससे कुछ फर्क नहीं पड़ा लोगों को, ठीक है, कोई हेट्रेड नहीं उससे फैली, disobedience of law and order नहीं हुआ. All right? The intention of causing disorder or inciting people to violence was the sine qua non of the offense. Sine qua non means condition precedent. All right? Condition precedent. The intention of causing disorder or inciting people to violence was the sine qua non of the offense. The court noted that there was no averment in the complaint that hatred or discontent was brought toward the government established by law in India. The court opined that hailing a country without denouncing the motherland did not constitute an offense of sedition. So this is what the court has said. Hailing a country, आप कुछ भी बोल सकते हैं, यूएस जिंदाबाद, कनाडा जिंदाबाद, all right? Hailing a country without denouncing the motherland did not constitute an offense of sedition because it did not incite armed rebellion, subversive activities, or encourage feeling of separatist activities. All right? Therefore, prima facie, there was insufficient material to connect the petitioner with the commission of crime. The court observed that the police had already seized the electronic device and filed a charge sheet, and there was nothing to show the custodial interrogation of the petitioner was necessary. Therefore, no fruitful purpose would be served by detaining the petitioner in custody. So what the High Court has said, bail की कुछ conditions होती हैं कि सर अभी bail मत दो इसको, इससे हमें पूछताछ करनी है, पुलिस कस्टडी में इसको रहने दो, ठीक है. So what the High Court is saying कि आपका फोन, इनका जो फोन है आपके पास है, and there is nothing to show कि आपको custody इनकी चाहिए, all right? Therefore, there will be no fruitful purpose would be served by detaining the petitioner in custody. So the court, what it did, court ने उनको bail दे दी. The court ordered his release on bail in the sum of 50,000 with one surety of like amount. All right? This was the case. Now we will look at the section also. जो पहले section था 124A sedition. Whoever by words either spoken or written, or by signs, or by visible representation, or otherwise, brings or attempts to bring into hatred or contempt, or excites or attempts to excite disaffection towards the government established by law in India shall be punished with imprisonment for life, to which fine may be added, or with imprisonment which may extend to 3 years, to which fine may be added, or with fine. All right. So अभी जो नया सेक्शन है 152 BNS, इट इज ऑल्सो काइंड ऑफ सेम. ठीक है, सेम ही वर्ड्स हैं इसमें भी. द थिंग इज, वन मोर थिंग मैंने आपको कराया था, एक्स पोस्ट फैक्टो लॉज. ठीक है, एक्स पोस्ट फैक्टो लॉज वी ऑल्सो डिड. सपोज करो शोरे एंड सलोनी इज ऑल्सो देयर आई थिंक. सपोज कि 124A सेडिशन जो है, ऑलराइट, द एपिलेंट इन दिस केस सुलेमान अगर अरेस्ट होते 2025 में, ऑलराइट, 2025 में उनके ऊपर BNS लगती, ऑलराइट. बट सपोज कि 2023 में ही वाज अरेस्टेड एंड देन जो भी नया BNS आया है 2022 में ही वाज अरेस्टेड एंड नया एक्ट क्या हम उनके ऊपर लगा सकते थे?
No, sir.
नहीं लगा सकते. सो दैट इज एक्स पोस्ट फैक्टो लॉज, कि जो प्रेजेंट क्रिमिनल लॉज हैं उनको हम रेट्रोस्पेक्टिवली नहीं लगा सकते. ऑलराइट. सो दिस वाज अबाउट द फर्स्ट केस. These were the sections involved: section 152 of BNS, section 124A of IPC. ये पहले था. ऑलराइट. सेम एक केस में इन चंडीगढ़ नीलम होटल एक 17 सेक्टर में, उसके पास एक पर्सन ने ही शाउटेड खालिस्तान जिंदाबाद. ठीक है, खालिस्तान जिंदाबाद बोलने से भी जो पंजाब एंड हरियाणा हाई कोर्ट ने है, द पंजाब एंड हरियाणा हाई कोर्ट सेड कि नो वन वाज नो वन वाज अफेक्टेड, किसी को कुछ अफेक्ट नहीं पड़ा, आर्म्ड रेबेलियन नहीं हुआ. सो ओनली सेइंग खालिस्तान जिंदाबाद इन इटसेल्फ would not attract 124A sedition. All right. So this was the case. Suleman versus State of Himachal Pradesh, 2025. All right.